All right, so let me introduce Chris Reed. Chris is General Counsel of the Nonprofit Insurance Alliance. He's had a long career as a lawyer, patent law, also working at the University of California in Santa Cruz, working for the technology industry, for Borland, and he's now leading the Nonprofit Insurance Alliance, which is one of the members of our Codex Insurance Initiative, and they're really doing really interesting work on changing the way they make insurance available to nonprofits. And so, with that brief introduction, I will turn it over to Chris, who will MC our LEX Talks Part 2. All right, over to you, Chris. Please join me in welcoming Chris.
Yeah, thank you, Roland. And Nonprofit Insurance Alliance is very excited to be working with Stanford and Codex and all the other affiliates and building. We're a 501c3. We serve only other 501c3s. And even though there's a lot of organizations here that aren't nonprofits, really we're building something that I think is designed to be used by all the different segments. So thank you for having us and holding this. Danny Toby will be our first speaker in this section. Danny's a medical doctor and a software entrepreneur who represents life sciences, technology, and healthcare clients in a variety of regulatory and litigation matters. He does this in front of the FDA, CDC, HHS, CMS, private payers, tort and commercial litigation. He leads Insider's 2020 list of top lawyers helping companies adopt artificial intelligence and helping companies navigate the legal landscape and emerging and disruptive technologies. Today, Danny will provide some answers to questions like, how will AI products transform regulation? How long can humans stay in the loop? What will precision devices do to population-based regulation? What happens when the doctrine of learned intermediary when we are neither learned nor intermediary? So with that, thank you and welcome to Danny.
Thank you so much.
Yeah.
Thank you so much for that very kind introduction. I'm thrilled to be here. I just wanted to do an informal poll of the audience first. As a lawyer, I'm always curious about this. Who here would characterize themselves as a tech optimist? Okay. Who's a tech pessimist? Okay, well, I'm laughing because one of the two people to raise their hands is my colleague at a law firm. We are pessimists by nature, and I think that's because out in the trenches, practicing law day to day, we're often dealing with what has gone wrong. So I'm a products liability lawyer, and I'm on the defense side most often. And so that means when something goes wrong with a product that we hoped was safe and reliable, and something happened out in the field, we go and investigate. And part of our work is figuring out what really happened. Did something go wrong? We look into the root cause analysis. And then we, if there's litigation, defend the company and try and explain why the security processes and the safety measures that were in place were reasonable and sufficient in the way that each industry demands it. But I want to test a thesis here today that I think because of AI, we are in the awkward adolescence of the grand life cycle of regulation. So for hundreds of years, lawyers and regulators have effectively approached products and services in about the same way, and I'll describe what I mean by that. And I think I know where we're going with data analytics and AI and how that might change regulation. But I think we're stuck in a mushy middle right now, and we're going to be there for a while because nobody knows where the dust is going to settle. So I want to talk about that as well. What does now look like? And as lawyers and as regulators, how are we grappling with that? So it won't surprise anyone to know that the whole world right now is wrestling with the question of how do you regulate artificial intelligence. And the first question when you take on something like that is, what is artificial intelligence? As lawyers, we have to be able to define the thing that we're trying to regulate before we regulate it. And you're actually seeing the opposite happening right now. Nobody has come up with a particularly good, serviceable regulatory definition of artificial intelligence, and yet there are over 800 active national level policies in progress to try and govern this thing that no one has quite defined yet. And you may think this is hyperbole, but the Artificial Intelligence Act, the Europe's sequel to GDPR, their regulation that is going to regulate all of artificial intelligence, they've been working on it for 2 years. And deep into the second year, without irony, they had a list of outstanding items, and first among them was the definition of artificial intelligence. So this is real. We're looking at major nation or global regulation for something that we can scarcely define. So where does that leave us? As a products liability lawyer and a regulatory compliance lawyer, I've been doing this the old-fashioned way for a long time. And I'll use healthcare as an example, because that's an area I work in a lot. But you can extrapolate this to a lot of areas. So we have a long process, and let's call that the pre-market process. And that's where you think about your product, and I don't care what that is. It could be a widget, it could be a person, like a doctor. You have something that you want to release on the world. So what do? We train it, we educate it, we test it, we make sure it's good. If it's a drug, that means years and years of trials, first in a petri dish, then in animals, then in people, and finally, you give all that to a regulatory body, and the regulatory body says, okay, we're convinced this is safe and good enough to put out into the world. And then the assumption basically was, once that's done, that product is out there. And sure, there may be at the margins, an occasional surprise investigation, or what we call in the field passive surveillance, people sending complaints, and if enough complaints bubble up, the agency might send out a regulator to look into it, to investigate it. But most of the time, things are really quiet until there's a lawsuit. And then all hell breaks loose. Products get recalled, billions of dollars get transferred, lawyers get very, very wealthy, and sometimes that's based on nothing, the scarcest of evidence. But the point that I want to make here is 90% of the focus was on the pre-market stage. So what does AI mean for that? Well, my view is that AI-enabled products really threaten that balance, that traditional way of doing things, because AI challenges a lot of our assumptions about what a product is. First of all, it blurs the lines between finished and pre-finished product. So for a drug, you might test it for 10 years, but once you put it on the market, you're not changing it again. That compound stays the same. But with the pharmaceutical and biotech companies I work with some of the newest ideas that are coming out, you might have a diagnostic, a digital diagnostic or therapeutic that's out there that continues to evolve in the field. It takes in new data, it learns new things, it's iterative, and it can very quickly get outside the bounds of what was approved by the regulators. Another key area where AI is sort of blurring what regulators are used to look at is the difference between a product and a service. And, most of the time we think about having a human gatekeeper for a lot of these sort of high-risk, highly regulated products. So think about, a CAT scan machine gets approved, it goes out to market. The patient doesn't just walk off the street and plop themselves in the CAT scan and get the output and go do something. It goes through a learned intermediary, and that's the phrase that was used in the introduction. And that matters a lot because there's a whole legal doctrine built around learned intermediaries. They are the gatekeepers that stand between consumers and this set of highly regulated products. But one thing we're already seeing is AI-enabled medical technology that is more learned than the learned intermediary. And that puts doctors in very tricky situations because they're now faced with a situation of thinking, do I override the recommendation of this device because I have all this medical training and I know this is an anomalous recommendation? Or do they say, wait, this thing is trained on terabytes of data, it's seen more patients than I will ever see in my lifetime, and my God, if I override this, maybe I'm the one who doesn't know what's going on, and I'm the aberrant thinker on this. So we've got this very awkward situation where we have sort of undermined the learned intermediary. And then the third thing that's really changing is regulation used to be very outward in. So if you wanted to know if a product was good, they would send out the inspection team, go to the manufacturing plant, or buy a bunch of samples off the shelf, and they would spot test them. And that was basically the way it was done. Now our products are shedding so much data that we are able to harvest in real time scores of information to detect how these products are doing. And so then the question becomes, what do you do with all that? Well, I think the future looks something like this. We've already seen it start with FDA and other agencies, but in the future, regulatory bodies are going to need a much better infrastructure to ingest all of this data, to process it, to look for signal detection, and then to go out and hopefully predictively stop problems before they start. Now, a lot of agencies are already starting to do this. FDA has had a big push for data analytics and data science internally. Financial regulatory agencies are doing the same thing. There's a lot of fraud detection and looking at anti-competitive conduct using cartel detecting programs. But we're nowhere near where I think this ends, which is an amount of data that no human regulator can manage. And so we're going to have a much stronger infrastructure of data intake in these regulatory agencies, and then processing, and then really triaging for the regulators. But where are we today? Because we're a long way from that. Where we are today is a fuzzy middle ground where all our regulatory agencies are racing to catch up with a technology that keeps changing. And I'll give you a really startling example about that. So the European Union and Parliament spent 2 years drafting the AIA. And it was almost exclusively focused on narrow task-oriented AI. So tools that sit on top of data streams and typically spit out a binary answer. Is this fraud or not? Is this a disease or a benign? And they were working very hard to come up with ways to regulate that. Well, then ChatGPT and generative AI came out, and suddenly it flipped over upside down 2 years of work. And everybody's thinking, okay, we had a great idea about how to do testing of narrow purpose, single purpose AI. You know, we knew what the goal was. We knew what we required for false positives and false negatives. We know how to judge that. Now you have everything machines that are increasingly being adopted where how do you judge the output of something that can answer just about anything? So regulators are really wrestling with that, and the common denominator is the impact assessment. And that's where I want to leave you is I think that's over the next 3 to 5 years what you're going to be hearing more and more about is companies that are deploying AI in products and services are going to be required to audit themselves and then potentially to have third-party auditors come in. And that's where the rubber meets the road. What are they auditing for? You know, everybody's had a responsible AI policy now that says AI must be fair. It can't be biased. It must be safe. It must be trustworthy. So one of the things we're doing at DLA, working with Megan and others at Codex, is really trying to say, how do you take those generic terms like fairness and bias and turn them into mathematics so that companies can then truly measure, are they meeting these impact assessments, and then reporting out, yes, our AI is sufficiently safe to be in the market. So that's where I'm going to stop now. We know where we've been. I think we know where we're going. The messy middle is a period of self-auditing and external auditing, and I think you're going to be hearing a lot more about that in the next few years. Thank you very much.
Terrific. Thank you. Thank you for that, Danny. Okay, next we're going to have Genevieve Heitkamp, who is a senior implementation engineer at Recidiviz. Recidiviz is a team of technologists that partner with corrections directors, probation and parole officers, policymakers and people in prison, and on supervision to design tools to bring real-time insights into what's working, what isn't working, what's actionable, next step leaders can take to improve outcomes. Please join me in welcoming her to talk about this important work.
Perfect. Okay. Hi, everyone. Thank you so much for having me. My name is Genevieve Heitkamp, and I'm here today to tell you about how the organization I work for, Recidiviz, is working to close the criminal justice policy implementation gap. At Recidiviz, we are finding places where policies already exist to reduce criminal justice time in the system and help departments of corrections make sure they are acting on those policies as efficiently as possible. A major component of that work is working with departments of corrections and their data, which sounds like potentially an easy thing, but it actually is not. Here's an example. This is Angie. Angie was sentenced to 4 years probation for a drug charge. She did everything she needed to do to reduce her sentence by half, but she remained on probation. Why did that happen? The thing is, her parole officer, Allison, is responsible for 90 people, and to actually get released, Allison has to check 20 different requirements for each individual, and that information of those requirements lives in 5 different databases. 90 people, 20 requirements each, 5 databases. I'll let you do the math, but as you can imagine, that creates a lot of friction to be able to actually implement policies and release people that are eligible like Angie. So unfortunately, there are hundreds of thousands of people that are stuck in prison or on supervision due to this fragmented data. As a senior implementation engineer, my job is basically to understand where data about things like incarceration movements lives, which may seem like an easy question, but more often than not, it's actually a daunting task because of how complex these data systems are. And feedback that we get every day from people that are working with this data is that it's incredibly difficult to track all of these requirements, much less actually complete the required paperwork or tasks to actually get someone discharged or downgraded. And so this is a really amazing opportunity to work with agencies on the implementation side of the work. I want to take a small step back to talk about why Recidiviz specifically is working on the implementation side. We know there are many people, we know there are many people in the criminal justice space trying to fix different parts of the system. In particular, we have legislators who are designing and passing policies, and many of these policies do have the goal of shrinking the system, and there's actually bipartisan alignment to shrink the system. So you have things like earned time, home confinement, early discharge, which are all really great opportunities to move people out of the criminal justice space faster. However, there's way less focus on the implementation side of these policies. So the actual implementation falls on individuals like parole officers, and if a policy has, rightly so, 20 different requirements that someone has to meet, it's up to individuals to adapt their processes to track each of those requirements and then figure out when a person might actually qualify for an opportunity. So with this fragmented data, it's an administrative nightmare. It's almost impossible to actually follow through on these policies that are getting passed in an efficient and timely way. So if we can find a way to automate that process, we are able to basically create an untapped mechanism to remove people from the system using existing laws that are already in place. And I will fully acknowledge that many criminal justice problems are not engineering problems, but this one actually is. And here's where Recidiviz comes in. Our mission is to reduce incarceration and correction spending safely and at scale. And the way we do that is by building tools that shift agency policy and staff behavior. Specifically, one of our current focuses is on identifying those individuals who are eligible or almost eligible for discharge or downgrade based on policies that already exist and implement those policies effectively. And so there is an incredible opportunity here. We don't know of any other single intervention with this size of potential impact. Today, our analysis suggests that there are over 50,000 people who are eligible for downgrade or discharge, and over 150,000 people who are just 1 or 2 steps away from being eligible. Now, for any of you skeptics out there, you might be thinking, can this actually work? Does this actually work? We ran a pilot in Idaho to get some people off supervision that were already qualifying, had the requirements. And within 6 months, we were able to discharge or downgrade 5% of Idaho's probation and parole population. So let's go through an example here. How do we determine that someone might be eligible for release? How might we actually do this? First things first, we start by getting all of the data from all of those different sources that I mentioned earlier. And we calculate things like the total incarcerated population, the people that might potentially be eligible for an opportunity, and then go in through the requirements of that opportunity. So for example, in here we're thinking about something like geriatric parole. And is someone eligible to be downgraded or put on parole based on those requirements? That takes our population from 140,000. If someone's on their first incarceration stint, that takes it down to about 75,000 people that are still eligible for this opportunity. Next, we ask if someone has been incarcerated for over 10 years. That furthers our funnel quite a bit, but we have about 22,000 people that are still eligible for this. And then let's say our last requirement is something like, are they over 60 years old, which narrows our funnel to about 6,000 people. Now, 6,000 people is quite a few people that are today already eligible for a policy that is implemented. We just need to actually make sure that we file that paperwork and get them discharged or downgraded. So you can see that there's a lot of potential moving forward in this, and it becomes really exciting to see that impact multiply over time. So with this work, Recidiviz has two main goals. First is to identify people who are succeeding, autofill any forms, and get them released as quickly as possible. We do that by understanding the policies that already exist, find out where the data related to that lives, and then automate the eligibility by aggregating it on our end of things and showing it to parole officers who can actually make movements on it. We estimate that right now there are about 5 to 10 unimplemented policies per state. And we know that from experience, many of these policies have 20 requirements or so that live in many different databases. We also know that parole officers are overloaded with their caseloads. They have sometimes upwards of 100 different clients that they are trying to understand how they can move through different policies. So any tool we can provide to them is very, very impactful. And any opportunity we can provide to make their work easier is an opportunity to get more people move through the system faster. You can see on the right there, it's an example of one of our compliant reporting tools that's actually aggregating data and servicing people that are already eligible for compliant reporting in a given state. The second main goal of this work is to highlight people who are almost eligible for release and then prompt officers to change their behavior. By doing this, we're able to really change the mindset of parole officers from reactive to proactive. As I mentioned, they have a ton of work, and more often than not, they're thinking, how do I get through the backlog of my tasks, as opposed to what's the best way to move through all of this. And so each workflow that we are, first of all, removing people from the system that are already succeeding, we free up resources to support people who need it, and we can reveal certain bottlenecks or policy priorities. We really are excited mostly about this because the types of conversations that we can have with parole officers and various different parts of the agency now have shifted from I'm so overwhelmed to things like, what are the 1 to 2 things keeping someone from liberty? You see an example here of someone that needs to stay on minimum supervision for a little bit longer and then reduce their fee balance, and then they are eligible for release. So perhaps parole officers can be working with an individual to move them towards that. You also shift the conversation a little bit more to how officers are prioritizing their tasks. And additionally, you can compare across officers. So how many officers are helping the individuals they're working with to succeed versus being more punitive over time? And perhaps maybe we need to work with those parole officers that are more punitive to shift their behavior to make it a more equitable space for everyone to have a chance at these opportunities. Now, I talked a little bit at the beginning of this presentation about Angie. Angie was stuck on probation, as we know, because of administrative bottlenecks. And today, after Recidiviz processed her Idaho eligibility data and surfaced her case to her parole officer, Angie, she is off of supervision and is working to become a drug and alcohol specialist. So it's through the eligibility workflows that we can implement policy more correctly and efficiently. As a reminder, this policy already exists within a state. We are truly just optimizing it so that people can access the data they need to get people to the place they're already supposed to be. So this matters on an individual level for people like Angie and Allison, and it also matters for the movement as a whole. As of today, Recidiviz's work to improve the system through data efficiency improvements has removed 71,300 people from the criminal justice system. Not only is this a huge cost savings, that's 1.1 billion in correction spending saved, but this work is critical because it adds momentum to the movement to create a smaller, safer, and more equitable system as a whole. And we are extremely excited to continue to partner with states and integrate this implementation work now and far into the future. Thank you so much for your time.
Thank you. Boy, that is a big impact. Very important work. All right. Tony Lai is our next presenter. And Tony is co-steward of Mother Tree Labs and the Wilbur Nature Workshop and a fellow here at Codex. He's working on computational law and blockchain for public goods and ecological transition. He's been a visiting professor teaching legal engineering for the biosphere, a lawyer, researcher, and technology entrepreneur, advising and working with companies, governments, nonprofits, bridging from new approaches and tools at the intersection of law and technology to use cases in community sovereignty, access to justice, data governance, compliance, and the management of risk and resources at the local and global scale. Today he will share his insights on creating impact at the nexus of computational law and blockchain for public good and ecological transition, from the bottom up as well as the top down angle.
Thanks very much, Chris. Wow, it's really nice to be here, 11th year in a row, and this community keeps getting better. Wow, so many smiling faces. I'm gonna use this, if that's okay. Okay, how's that? Can everyone hear me okay? Fantastic. Okay, so let's go back to the starter. This was supposed to be a video, but it's essentially just a picture of the Amazon rainforest and the sort of the basin. I've just been to visit the Sacred Headwaters initiative in the Amazon, and I think part of the piece I'm here to share with you today is about weaving between communities, between places and peoples, between intersections at this crossover point of nature, finance, law, and technology, and about how that may impact the future of law, certainly how I see it. I want to also channel some perspectives from a recent gathering I was at where I got to listen to some elders, Joanna Macy and Kim Stanley Robinson in particular. So a bit of a hat tip to them for the sort of the framing of this talk, which is really about how do we value nature when it's alive instead of when it's dead. How do we think through the incentives and the coordination mechanisms? We talked about global public goods in the introduction. Thank you, Chris. Yeah, I guess this is in the context of coordinating action around climate change and around saving the planet, like this idea that we're destroying nature. Various international legal scholars have identified critical weaknesses in the current arrangements that focus around jurisdictional gaps, participation gaps, and incentive gaps. But one of the things I've been learning is that it's also around the way that we see nature, this idea of is it dead or is it alive, or is it, in certain worldviews, nature is considered as a family member, that we're not really separate from nature. I guess going back to Kim Stanley Robinson, he's a big hero of mine, an elder, he's a science fiction writer. He wrote a book in 2020, a science fiction novel called The Ministry for the Future. And it imagines a not too distant world where central banks worldwide come together and they create a carbon coin, essentially a monetary policy-based solution to the climate crisis. So we met at COP26 in Glasgow, and a few months later we decided to organize a gathering focused on these intersections of nature, technology, politics, and philanthropy. And taking some inspiration from his book, we had some further gatherings. There's another one later this month. But essentially it's to look at both the top-down and the bottoms-up approach to this. And here, which is part of the materials that I included for CLE credit for this, you'll find two pieces of research which I've been sort of loosely involved with, but they come at the problem from two very different angles, and two angles that I'm kind of arguing are really complementary. The first is a white paper written by friends and colleagues at the Open Earth Foundation, really wonderful nonprofit. Encourage you to check it out. And the other is a bioregional plan by the group that hosted us in the Amazon Sacred Headwaters Initiative. And so these sort of, in a sense, represent these two different perspectives, top down and bottoms up. But I guess first of all, I just want to try something. I want you all to imagine with me, maybe if you'd all be good enough to actually close your eyes. Imagine being alive, made of everything that this planet has provided. Imagine being alive with a heart. Imagine breathing and being alive with lungs, and how amazing that is. Now take a deep breath. It feels great, doesn't it? This is a video, again, I don't think this is going to play, unfortunately, because but essentially it was a video, and I'll share this with you afterwards, those who are interested, but it's a video of the beating heart and lungs of our planet. For the first time, we've been able to see with satellite data exactly how the Amazon rainforest works. And if you look at it, it's kind of like beating this hydrological cycle. And the water that goes into the Amazon actually rains 9 times on the Amazon before it gets distributed up and down the Andes. And it really looks, and you can see how this organ of our planet operates just like our organs and beats this water around the planet. And unfortunately, we've been destroying that. And that's part of these incentives and coordination mechanisms that have been in place. We've been destroying it through mining, through extraction. There are folks on the ground who have been taking the money because they've been brought into this money economy. And essentially, there's issues going on in the heart of the Amazon where oil companies have been bringing out, and they've been, operating on fairly loose environmental standards, very different from, when there's an oil spill, the Exxon Valdez, and there's a lot of attention on there. Essentially, when there's an oil leak or oil spill, or just the sort of the spraying of oil on the roads, there's like the sort of the overflow of the wastewater, millions and millions of tons of water just sort of pumped into this land, these resources, these rich fisheries and freshwater of these local communities. And that's all just playing out because of these incentives and mechanisms in place. And so Ecocoins, this is this mechanism that builds in at this intersection of nature, finance, and technology. And I think most people who think about coins and think about blockchain and crypto have been thinking about investments and speculation. And I think the associations that we have when we think about this word are probably quite fair in terms of the ways in which we think about transactions, the ways in which we think about, what it means to buy something from someone in the context maybe where you have power over them. And essentially this is, part and parcel of the way that day-to-day law and transactions operate. We essentially instrumentalize our counterparty as some sort of agent as part of a transaction. We see them as a human being that is there to help us get something, and maybe we're not necessarily presencing the fullness of who they are into the relationship. One of the interesting contexts that sort of hit me when I came back 2 weeks ago out of the Amazon was the doctrine of discovery. Who here has heard of the doctrine of discovery? Anybody? Brilliant. So, well, it's a 15th century papal bull that was issued that essentially authorized colonial powers such as Spain and Portugal and others to subjugate peoples in Africa and the New World, as long as those people on the land were not Christians, so to speak. And this essentially has played out, and it was only rescinded a couple of weeks ago. It's lovely that this Pope is, all down with the indigenous friends and everything, but this has actually embedded itself into, the way that we think about property, the way that we think about people who were there before us. And as part of this, I think it's important to just remember some of these assumptions we bring when we think about law and the ways that law can perpetuate power imbalances. In the 1823 US Supreme Court ruling, indigenous people had only rights of occupancy over the lands that they lived on, and as long as they were there. And as late as 2005, the doctrine of discovery was referenced in case law in New York State. And so when we think about computational law, and we think about what kinds of systems of power we're encoding, what kinds of dominance, what kind of extraction we might be encoding, I think it's important to just remember those people like, Einstein, who've talked about we cannot solve our problems with the same thinking or level of consciousness we use to create them. And so when we think about the $1.5 to $3 trillion apparently needed in capital deployment to tackle climate change and nature loss each year, there's a whole bunch of things that we need to maybe think about in terms of the lenses that we apply. The required financing maybe cannot be achieved in the current political dynamics, given some of these equity discussions around the global north, south, industrialized versus industrializing nations, and some of the questions that we might need to ask about some of our defaults and associations that are going in. I encourage you to read the bioregional plan by the Amazon Sacred Headwaters Initiative. It includes some wonderful principles about what bottoms-up design and involvement of indigenous peoples might look like. What are the principles that around co-governance, around self-management, around protecting and restoring life and ecological integrity? Because indigenous peoples are currently, for what little lands they have left, they're currently responsible for stewarding over 80% of the most biodiverse regions on the planet today. And so they're doing something right. And if we can potentially enable that kind of bottoms-up self-governance, this particular bioregional plan relates to 30 million hectares in the Amazon. And there's a lot of different legal principles coming in. There's rights of nature that are embedded within constitutions in Ecuador. There's legal personhood that's taking place in Aotearoa, New Zealand. And there are various different constitutional discussions happening, indigenous peoples to indigenous. And with the right kind of allyship, we can maybe make some change. I've been asked to move on quickly, and so I'm just going to pass on through. And hopefully I can just leave you with a little poem by one of my favorite poets, and Rainer Maria Rilke. Why then do we have to be human and keep running from the fate we long for? Oh, not because of such a thing as happiness, that fleeting gift before loss begins, not from curiosity or to exercise the heart, but because simply to be here is so much, and because what is here seems to need us. The vanishing world that concerns us strangely. Us, the most vanishing of all. Once for each, only once. Once and no more. And we too, just once. Never again. But to have lived even once, to have been of earth, that cannot be taken from us. Please be in touch if any of this resonates with you. We at the Codex Blockchain Group are looking at ways in which these new legal and technical infrastructures can serve all of humans, all of life, and the future of law. Thank you very much.
Thank you, Tony. Again, another important area of work that's going on. Our next speaker is Rebecca Liao. Rebecca is co-founder and CEO at Saga, a protocol for launching the next 1,000 blockchains in the multiverse. Previously, she was co-founder and COO at SkewChain, a DeFi project, and part of the early team and director of business development and head of Asia at Globality, an AI startup. She began her career as a lawyer at Skadden and served on both the Biden and Clinton presidential campaigns in 2020 and 2016. Today, she'll be talking about why blockchain and crypto are here to stay. Simple answer, you can't kill this technology. But more seriously, she'll talk about the movement for ownership and self-determination that has driven this industry to persist and grow. The recent regulatory activity in this space has highlighted the need for a sensible and adaptive framework for crypto assets going forward, and more importantly, for changing the conversation. Please welcome Rebecca.
Thanks, everyone. I'm going to adjust this real quick. How y'all doing? Good energy for the afternoon? Still doing all right? All right. You're going to get some espresso in your system. So it's great to be here. I'm Rebecca. I'm co-founder and CEO at Saga, which, as Chris mentioned, is a layer 1 protocol for the next 1,000 chains in the multiverse. So I'm supposed to talk today about why blockchain and crypto are here to stay. And I'm starting off by saying it should have died a long time ago. You don't lose tens of billions of dollars and stick around as an industry, whether it's Terra Luna, FTX, all the collapses in 2018 and 2020, we should have died a long time ago. So let's talk about why we're still here. So up here, I have 3 logos. These are probably the most popular applications among Gen Z and millennials that are under regulatory scrutiny. So TikTok, y'all recognize, Robinhood, and then, of course, the various crypto applications. All right, so compared to other Gen Z and millennial favorites that are under regulatory scrutiny, I would say that crypto lacks passion and relevance. That's our problem. Okay, so let's look at some stats. For TikTok, they have a whopping 150 million daily active users in the US alone and 1 billion worldwide. And each person who uses TikTok, they log on for an average of 95 minutes a day, and they're logging in about 8 to 10 times a day. I think that's the very definition of a smoke break. All right, so who's using it? 60% are female, 40% are male. About 60% are between the ages of 16 and 24, it's considered Gen Z. 26% are millennials, 31% Hispanic Americans, 30% Black Americans, and 18% white. Okay, so just an example of some of the demographics of TikTok users. There's roughly even distribution of users across all income levels. So if you break it down into about 5 different income brackets, each comprise about 20% of TikTok users, so fairly universally popular. Robinhood, let's move on. Robinhood stats, 22 million users, still pretty good, and the average age of a user is 32. All right, 70% are male, 30% female, starting to see a little imbalance there, 19% Gen Z, and 51% millennials. You got to have cash to play, so not surprised about that. 19% are Hispanic American, 10% Asian Americans, 9% Black Americans, and the figures there are relatively close to the general makeup of the US population. Okay. Now, importantly, 43% of Robinhood users have a FICO score less than 650. This is illegal in financial rooms, so you know that that's not wonderful. It's an average account balance of $3,600 as of early last year. Okay, so let's talk about crypto stats. 118,000 whopping daily active users. 70% are men. 30% are women, 13% are Gen Z, and 57% are millennials. Okay. 62% white, 24% Hispanic Americans, 8% Black Americans, and 6% Asian Americans. And there is a higher income in this group. Higher income individuals have transferred more money into crypto accounts as a share of their net worth. So you're probably starting to see a pattern here. Let me make it explicit. Active users, gender, age, and income distribution are why we are not demographically compelling for either Democrats or Republicans. Okay, so crypto is volatile, but we are anti-fragile for whatever reason. Let's explore why that can be. Okay, so these are some of the greatest hits of regulations that have just gotten the facts wrong about what crypto is, what the purpose of it is, how it operates. So CBDCs should be on permission chains. Permission chains are kind of useless. Algorithmic stablecoins are inherently unstable, not true. We need to have validators and developers give 1099s to people who use chains. Peer-to-peer transactions are fine as long as there are no smart contracts. Smart contracts are how blockchain kind of works. And random tokens are securities. These are all wrong policies and they are old policies. Meanwhile, this industry has put out a pace of innovation that is simply breathtaking. So I would say 2014 timeframe is when you saw protocols really, really pick up. And then how blockchain is organized is you have your protocols and then you have your applications building on top of them. So since 2014, we have seen an absolute explosion of innovation in this area. And for those of you who are familiar with crypto or who sit in the industry, you know that even for us who do it day to day, it's kind of hard to catch up. All right, so policy recommendations, once again, are outpaced by innovation, okay? But crypto is not entirely perfect. The narratives that we have been putting forth, that we are new financial rails, that we're anti-corrupt, we're transparent, and that we're all about ownership, these narratives have not resonated. They are old stories. We keep repeating them. They are not compelling. So they are also wrong and old. So we need a new way of understanding crypto. This is the anti-fragile part. So why are we here? It is because we build. It is because we own. It's true, we own assets. And it's because we ultimately choose. So we build, we own, and we choose. We choose the company we keep. This is the anthem of crypto. We are here because Web3 is about the timeless value of self-determination. So I'd like to talk to you a bit about Saga. So going down the wormhole here, it's one of our themes at Saga. The wormhole is the fastest way between 2 points in space. So let's talk about who is building on Saga. So our innovator program, which encompasses our entire ecosystem, everyone building on Saga, we are at 169 projects. It's quite a lot. They are gaming, lots and lots of games. They are NFTs and entertainment. They are DeFi and social. DeFi is distributed finance. And of course, it is fellow infrastructure projects. So by mainnet launch, which is about Q3, Q4 this year for us, we'll have at least 300 projects that are building on Saga. So why did everyone come here? Well, we were at GDC a couple weeks ago, and we debuted something known as the Saga Multiverse. And what did we want to do? We want to break the silos that have held us back from telling our stories. And we believe in the future of community-generated content and the decentralized control of gaming and entertainment. And so, welcome to the Saga Multiverse. So it is a full-stack production studio, and it seeks to combine sight, sound, and motion to allow creators to connect, create, and ultimately transcend. So we're seeking creative cohesion across a decentralized ecosystem and, of course, across universes. So the last thing I'll leave you with is a taste of what it means to be in this decentralized multiverse. Do we have sound?
Universe, the OG universe. It's pretty cool, I guess. But building in this universe can be boring. It can feel lonely. What if there was something more? Limitless collaborations.
Thanks so much, guys.